Welcome, everyone. Today, we're diving into the fascinating world of international law, specifically the Convention on the Taking of Evidence Abroad in Civil or Commercial Matters, commonly known as the Hague Evidence Convention.
That's quite a mouthful. What exactly is the Hague Evidence Convention, and why is it so important?
Great question. The Hague Evidence Convention is a multilateral treaty that facilitates the process of obtaining evidence from one signatory state to another without the need for consular or diplomatic channels. It was initially drafted in 1967 and signed in 1970, entering into force in 1972.
It enables smoother legal processes by allowing countries to communicate directly regarding evidence requests, rather than going through potentially cumbersome diplomatic routes.
So it sounds like it speeds things up. But was this the first time such an issue was addressed?
Not quite. Before the Hague Evidence Convention, there was the 1905 Civil Procedure Convention, which also aimed to tackle evidence transmission. However, it didn't gain much traction and was ratified by only 22 countries.
Interesting. I can see why a more effective solution was needed.
Now, let's discuss how the convention actually works. Each contracting state designates a central authority to manage incoming evidence requests.
And what does this central authority do?
The central authority's role is to receive and review letters of request to ensure they meet the convention's requirements. If they do, they forward that letter to the competent authority, usually a court, for execution.
This is critical because it ensures that the requests are processed according to each state's specific laws and procedures, as outlined in Article 9.
But what happens if a request isn't executed?
Good point. According to Article 13, the authority that receives the request must inform the requesting party if they cannot execute it, along with the reasons why. This transparency is key in maintaining trust between countries.
Wow, that sounds like a well-organized system. Are there any challenges in this process?
While the framework is robust, challenges can arise due to differences in domestic laws and varying interpretations of international obligations. But these are topics we can explore deeper in the upcoming chapters.
I'm intrigued. It's amazing to see how international cooperation can streamline legal matters. I can't wait to learn more.